with and one of them you do not. One of them will cost you something, one of them should not. Power of attorney, very important. I tell people, there are 2 documents everybody should have. And somebody always raises their hand and says, oh, a will. Not necessarily. Not everybody needs a will. You'd be surprised. You know, I tell people, if you have all of your assets joint or in trust or beneficiaries, designated beneficiaries, then your will is meaningless. You know, you could have a will that I leave everything to my beloved attorney, John Bigler. Again, no one ever does it. I wouldn't get a penny because everything is going out automatically. The will only covers those things that are in your name alone at the time of your death. You may not have anything like that, okay? And the other thing is, if you don't have a will, people say, oh, if I don't have a will, the state's going to come take it. No, the state's going to give you a simple will. You're an individual with 3 children, and you don't have a will. Instead of a probate, it's an administration proceeding, same court. And the state of New York says, okay, an individual dies with 3 children, each child gets a third. That's the way it goes. If you die with most people, if you have husband and wife, if you die without a will, spouse gets the first $50,000 and then half, and children get the other half. So most people have, you know, sweetheart wills, everything to my spouse and then to my children. Now, one thing, if you have a spouse in a nursing home and you've transferred all of their assets to you, you shouldn't have a will that says, I leave everything to my beloved husband in the nursing home. You want to change your will. But again, wills can be important, and certainly for people with, you know, lots and lots of assets, there can be estate planning. But, you know, a lot of times will is not as critical as people think, and sometimes it's absolutely unnecessary. But what is necessary, I tell people, what everybody should have, young or old, black or white, rich or poor, New York State durable general power of attorney, and durable means good even after you become disabled or incompetent, which is the only time you need it, and a New York State healthcare proxy. All right. The power of attorney, you're naming someone else, agent, co-agents, alternate agents, to act to handle your finances. All right. It used to be, you see what you have in front of you, this long, ridiculous form. It used to be 1 page, 1 side. Yes. And you signed it, and it had powers A through O. And if you didn't want the person to have one of them, you put your initials and a line through it. And O was all other matters. And we used that to transfer everything. And never charged for it. It was a simple 1 page, 1-sided form. And then the courts got involved and the legislature got involved, and they said, you know, we're concerned that maybe people are signing this and they're not really sure what they're signing. So they came up with, as only the government can, with the brilliant idea, little by little they decided, we're worried that people are going to be confused, so we're going to start making this form longer and more complicated. So if you were confused, it's like, what? So now we have this monstrosity, and this is actually 2 parts. And I've seen people, attorneys have done it. They're getting better. We've had this since 2009, but we have the power of attorney part, and that has to be signed by the agent as well as the principal and notarized. And then afterwards, we have the statutory gift writer, and the statutory gift writer has to be signed by the agent, by the principal, and it has to be witnessed, it has to be notarized, and it has to be witnessed by 2 people, okay? And if you don't have the gift writer, then it's relatively worthless, because the whole point of the power of attorney is, you know, now, it takes effect immediately, so you've got to be careful with it. You know, the original, I always do 3 originals in case some financial institution insists on having an original. But the originals, I tell people, you should hold yourselves. There's no reason to give them out. Because as soon as you give it to the agent, they can act with it. And again, I give it to my daughter. My daughter is an angel. But, you know, the bum starts whispering in her ear at night, you know, let's go get some money, the old guy will never know. And that may never happen, but if I'm waking up in the middle of the night worried about that, it's not good.
What happens happens if we signed it a number of years ago? We only signed one page.
If you signed it prior to, the new form going into effect, that one's still good.
Oh, okay.
All right? You know, and the problem with this is the power of attorney is subject lovingly to what I refer to as the nitwit theory. The nitwit theory says when you walk into a financial institution, you may be dealing with a nitwit who's going to say things like, oh, this is the old form, we only take the new form. And it's like, no, when I signed it, it was the new form, it's still good. Oh, but it's more than 6 months old, it's stale. It's not a donut, it doesn't go stale, it's good until I revoke it or I die. Oh, it doesn't have the name of our financial institution on it. That's a crime. They can't say that. They could be fined for it. But these are all the things that you will hear. All the nonsense that you'll the kind of stuff that you'll hear, yes.
I have 2 daughters. Do I need 2 powers of attorney?
No, you can name them as co-agents. You can name one as agent, one as alternate agent, but you can name them as co-agents, and then you decide if they have to act together or they can act separately. That's up to you. But again, if you have the old form, even the new form, I tell you, this new form, I've had people with the new form, and it's perfect. I know it's perfect because I did it. Okay, and they have problems. I had a retired judge, a good friend of mine, unfortunately passed, but he named his 2 daughters, and he was in the hospital, and I got a call from the daughters hysterical at a Chase Bank in Rosalind, and they said they're not honoring it. I talked to the man, why? Because we only honor it when it mentions one agent, not if they're co-agents. And it's like, what are you talking about? The form has a place for co. It's like, and I had to go through to the legal department. I mean, it's so frustrating sometimes. But you need to realize that with powers of attorney, you need to sometimes be a little obnoxious, and the people that you're talking with may have no idea what they're talking about. But it's like, this is my little fiefdom, and I woke up on the wrong side of the bed today, and I'm going to show you how important I am. And you have to deal with that. But power of attorney is important so that, I have all these, clever ideas of how to save money, but if you're not mentally competent at the time that we need to do this planning, then what happens? Well, without a good power of attorney, it means your family needs to go through a guardianship proceeding in court. And guardianship proceedings are wonderful for lawyers, okay? Because the person who wants to be a guardian needs a lawyer, and the person who's alleged to be incapacitated needs a lawyer.